My name is John Worley, and I'm the director of our certificate program at South Texas College of Law. Sherry Porter to my left, your right, who directs the program at Northern Kentucky, and Karl Okamoto is the director of their program at Drexel. Our idea was that rather than having a panel of three speakers, that instead we would just have a more informal discussion. We'd raise a number of issues and let each of us comment on them. And then from time to time we could stop and take your questions or comments. But in view of the fact that we've got as few people as we do, maybe we can just, if you feel like you have a comment or a question, just feel free to chime in. The first thing we thought we would talk about a bit is what purposes a certificate program could possibly serve. Are they valuable at all? What good do they do for students? Do they help with employment, help prepare for the practice of law? What good might they do for the school, and so on? And I guess, Karl, if you don't mind, would you like to start off?
Well, I often get asked this question by, I guess, rising 2Ls, because that's when they first start thinking about this. They see at our school we have three. We have a certificate program in health law, in intellectual property law, and then one in business and entrepreneurship law. Wasn't my title. And I'll tell you why we have those three and why we have the word entrepreneurship. Drexel added this law school 4 years ago as a way of completing its hand. It already is known as an engineering school and an information science school, so that's IP. It has a medical school, so that's health. And it has a business school, and its business school is, its claim to fame is that it's one of the best entrepreneurship business schools. And so in order to tie this new jewel in the crown, the law school with the rest of the university, and to market the law school as capitalizing on the great strengths of the university, of course we have now a IP concentration, a health concentration, and a business and entrepreneurship law concentration. I think that was the genesis. It was great marketing material. It made the website look good. It pleased other constituencies within the university that, okay, this law school is actually going to mean something to me too. And so I think that was its real motivation, and probably still is its real motivation, although there's some side benefits that I enjoy and I think have some potential to create value besides just smoke and mirrors. But from a student point of view, when I'm asked by that rising 2L, why should I do this certificate, and I have those people who are absolutely certain they want to do it, and they're the ones who are always looking for advice about getting all they can out of this very expensive education they're getting. And they're usually assuming that something about the certificate is going to help them with their job search, and then maybe further on with their career. I think a lot of people have caught the certificate buzz, right? You have to become a CFP or a CFA or whatever and add these credentials to your name because in your life it's going to create more opportunity. And my answer to them is no, that it's an absolute not valuable thing from that perspective. If you think putting that in your resume is somehow going to help you get that job at Cravath, which you otherwise would not have gotten, the answer is it will not, is my suggestion. Or any other firm for that matter, down the pecking order of your ambitions. And so, but on the other hand, right, I don't want to put myself out of a job. My answer is why it might be valuable is if you're like me, right? And that is you need a tour, you need a guidebook when you go to France, right? Or when you go to some foreign country. And having a certificate program is your guidebook, right? This is me telling you that if this is what you are vaguely interested in and you want to come out with some exposure and some set of competencies that law school has to offer, to the extent it does, this is the arc of curriculum that I'm suggesting, right? It's a way of organizing your 3 years. It's a, if you will, a guidebook, right? And whether or not you get the certificate really doesn't matter. You won't know until you hopefully already have that job you're aspiring to anyway. right? And no one's going to care about it when you're switching jobs 3 years down the line. That's not going to have to be relevant when you have a certificate in entrepreneurship law. But the fact that you took this arc of coursework, right, will. And I think most students, at least at our school, get very little substantial guidance in how to design what is otherwise a Chinese menu style of education, you know, A, B, or whatever, you can choose whatever. There doesn't need to be any coherence in your education at law school. Well, what I provide in a certificate program, what I think many certificate programs provide, is a notion of a coherent program of study, at least for one particular purpose. And so I think that's its main value.
Sherry?
I would tend to agree. I'd like to back up just a moment and tell you how we came upon having a center in a certificate program. Northern Kentucky University has been around since the late 1800s. We started out as an evening program at the Y across the river in Cincinnati. And we've always been known as the Lawyers Law School. And we have a very devoted alumni group, and they're very excited about the fact that we've always been able to produce students who can come out of law school and help them fairly closely to immediately. I'm an alum from Chase as well, so I don't know if that's completely true, but we've always prided ourselves on that. And but it's always been more towards the litigation. And in recent years, we've taken a little more of a look at the transactional side, and we set up 2 new centers 2 years ago. One is an advocacy center, which if you have to draw a line down the middle, which you know it's really hard to do, that would be your litigation. And the other side is transactional. We chose transactional just because it's a more encompassing word and can encompass so many other areas. I head up the transactional side because I was a corporate attorney in my prior life. And the focus really of both of these centers are really just to give our students more skills. Not that they aren't getting it already, but to put more of a focus on them getting the skills. With the Advocacy Center, and I was telling these gentlemen earlier that it was a little easier, they were able to repackage a lot of things that were being done because law schools historically have pushed more towards the litigation. You're looking at cases, blah, blah, blah. The transactional side's been a little more challenging because we've created new programs, new courses, and this new certificate program. And I look at the certificate program really, again, as a roadmap for our students so that they understand how you can take these pieces and parts. If you look, I do have our requirements in the handouts. We have some required courses, we have some elective courses, we have some other things. But we also sought out advice of our alumni and of the practicing bar when we were setting up the certificate program to see if they thought this would be valuable. And the overwhelming response was, oh my gosh, absolutely. Because that way we'll know you've set the bar pretty high with some grade requirements and other requirements that involve not only coursework, but externships, clinics, things like that. So that when our students really walk out of our halls, that they're really more practice ready are kind of our little marketing words, not come up with by me. And so I think this does have the value not only though for the roadmap that it provides our students, but I think it also, we're hoping, because this is very new, again, the certificate program is just within its first year, so maybe I'll have more to share 2 years from now, that it will be something that sets our students apart. As far as I'm aware in our region, we're the only ones that have, the only law school that actually offers a certificate in transactional law. And I'm really hoping, at least based on the discussions I've had with the practicing bar, that they will consider this, that if someone actually walks out with a certificate, that they will have gone above and beyond the regular law school curriculum. We're hoping it'll be a very rigorous program, which if you look at some of the grade point requirements, you know, getting a B in some of those classes, some of the students look at me, a B in tax, are you serious? That's where we're hoping this will go. I'll have more to report as we move on with this, but we're very excited. Our students are very excited, and the practicing bar in our area is actually very excited.
I guess I ought to give you a little bit of the motivation that supported our development of the certificate program. In part, we were concerned about the changing economics of law practice. It's our belief, and I think widely shared, that big firm practice is never going to be the way it used to be. In part, I think it's coming to look more like what smaller firm practice has always looked like. And that is, if you're going to pay six-figure salaries to new lawyers, they better be productive immediately. We don't have time to wait a year or 2 years for them to be profitable. They've got to be able to do something now in order to justify the salaries that we're paying them. So that would, sort of drove our concern about sort of skills orientation of our program, as opposed to perhaps a more business theory or economic theory orientation of the program. It's a skills-driven program. And the second thing, why do a certificate program in transactional practice at all? At South Texas, we have a long tradition of practice-oriented legal education. But it's like at Northern Kentucky, mostly in trial advocacy. We're proud of the fact that our mock trial and mid-court teams have won 104 national competitions. I don't think anybody else comes over 50. So we've been doing that quite well. But that has a downside for those of us who teach in other areas, and that is that the noise of the success of the trial advocacy aspect of legal education at South Texas drowns out everything else that we're doing. And so part of the concern was to be able to do something that would call to the attention of prospective students, enrolled students, alums, prospective employers, that we're doing something else besides training for trial advocates. And then, and particularly a transactional practice, because a variety of developments, legislative and judicial and other, in Texas, traveling under the label of tort reform, has made it very difficult for people to make a living doing trial work. This has had an adverse effect on both the plaintiffs and the defendants' bar. People aren't doing that kind of work anymore. They're finding other things to do. So we need to do a better job of calling to students' attention other kinds of alternative kinds of practice, not the things that they might have first thought about when they decided to come to our law school. So part of what we're trying to do is, I think I agree with Karl and Sherry, that we'd like to provide a sort of coherent course of study for students who are interested in doing this sort of work. But we also want to provide a concentrated educational opportunity that will get them, in your language, practice ready, doing sort of transactional practice. Is it useful for students? Well, I hope so. I hope that when they graduate, they are, in fact, ready to do things, that they can be immediately productive. Does it help them get jobs? Well, I don't want to undersell it, but I don't want to oversell it either. I think it does help, at least as a sort of signaling device to prospective employers. They can say, first, I'm serious about this, right? That they're willing to undertake the effort to meet the requirements for the program. But it also offers sort of a good housekeeping sealed approval that if they are going to meet the requirements, we're attesting to our belief that they are ready to be immediately productive doing that kind of work. And so is it the kind of thing that makes or breaks an employment decision? I don't know, but I do think it's a factor. And certainly our students are reporting that when they are interviewing, they get an awful lot of interested questions from people, and it gives them an opportunity to talk about the kind of work they're doing in the program. So I think it helps, but I don't want to oversell it. It's going to be the thing that will guarantee an offer that you couldn't otherwise have gotten. Well, maybe it would be helpful if we described a little bit about what our programs look like, to see how we're trying to accomplish those objectives. And Sherry was more generous than Karl or I. We're insisting that you look on the website to see what our programs look like. But Sherry, you've got a printed copy. Why don't you summarize what it is you're doing?
Absolutely, and I mentioned earlier that I always have to pull this out when I have to talk about it, because there were so many iterations before we actually got final approval, first from our group that was putting it together and then from the full faculty. And I anticipate that this will be a project in motion at some point in time. But this is our story. We're sticking to it right now. Obviously, there are going to be some required courses. I anticipate most certificate programs have certain required courses that you must take. We also do have a selection of elective courses. I think that will be something that actually is in motion, because we are adding more transactional courses on every semester. So I'm very excited to see that. So I look forward to actually that list going from however many it is, like 10 or 14 right now, hopefully to a much larger number. And I think that would be most helpful. That way students can really focus more in on their area. If they're really interested in IP, they can really do more of a focus there. Or if they're interested in healthcare, they can focus there. Probably one of the more interesting parts of our program is we do have an accounting and financing competency test. We had much discussion as to how do we ensure that our students walk out the door being practice ready without having any basic understanding of accounting and finance. We weren't really sure how to actually do that. We had many discussions about, well, we offer accounting for lawyers, we offer business basics, we offer corporate finance. Do we take these classes and require it, or do we have them attend some other mandatory course? We had so much discussion about it. And actually this idea was our dean's. He said, you know, we are a law school, and while we should be teaching some of these things, it's not necessarily our job, which within our confines, to teach them everything they need to know about accounting and finance. So we ultimately ended up with this accounting and financing competency test. And I will tell you that we have not administered our first test yet. It will be done this fall. But it really is very basic. And we are sharing with students the basic areas that they will need, that they will be tested on. So again, I'm the new kid on the block, so I hate to come and tell you it's been wonderful, our students have passed, but I don't know yet. But it's been well received by our students, because many of the students that are involved in this so far do have some type of business background, whether it be an accounting background, finance background. We have a large part-time program, evening program. So we have a lot of students that have already been out in the work world and have a lot of experience in this area. Maybe they're a banker, work at a financing, do real estate financing. So I anticipate that some of these students will be able to pass this with ease. For those students perhaps who cannot, they do have the opportunity to retake it. So I think it would be very interesting to see how many of our students actually pass it on the first try. So they can retake it. And if indeed they find that they're really lacking in an area, put the onus on them to be a self-starter, to go out and get that additional information. There are many programs that we offer through the Transactional Law Practice Center. On campus, there are so many programs they could attend without even going out and taking a class, that they could definitely obtain some competency. We also have upper level writing requirements, as I'm sure most law schools do, and they have to fulfill both of those. There's one that is a drafting requirement, and they have to fulfill that within a transactional topic. I will approve that, and I'll be fairly open and forgiving with that. And we also have a research, a drafting and a research. And so they will have to accomplish both of those within a transactional class, or like contract drafting. Most of my students do that. We also do require them to participate in 500 minutes of programming sponsored by the Transactional Law Practice Center. That really hasn't been a problem. When I set up the center, I also established a student group, because I think it's very important, in order to get buy-in, that you have buy-in immediately from the students. And I have a student group. It has about 100 and something members, generally active, probably 30 to 50, but attending most of the presentations. Usually it's a pretty decent showing of 80 to 100 students, which is really good for us, because you know, if you don't feed the students, sometimes they don't come. Maybe that's just at our school, we're the only hungry students. But they do keep track of that, and I have a form for them to keep track of that. They also do have to actually register for this program. And I do have a form that they fill out, and I have them actually come in and sit down with me to talk about where is it that they're trying to go? What do they want to accomplish by doing the certificate program? I again try to explain to them it's not going to be some magic key into some door that they would not otherwise be able to enter. But a lot of times I have students come in that are just like, well, you know, I'm kind of misguided. I don't really know where I'm going. And that can be very helpful to them. I can help aim them in a proper direction. We also do have a pro bono requirement at our law school. Students have to fulfill 50 hours of pro bono work. And we do require that half of that, in order to get the certificate, be fulfilled in some type of transactional law field. I will tell you, I was a little nervous when initially it was proposed that we put that in here, because I'm like, gosh, you know, I've looked at those pro bono opportunities out there, and you know, there are not as many in the transactional field as there are in the advocacy field. However, I've been pleasantly surprised and really excited to see new opportunities coming in based on getting this out in the community. One example, we had an alum who had a connection in Haiti, and when they had the horrible devastation that occurred, he had a connection with a company that was creating water purification systems. But he needed some non-disclosure agreements and some other contracts. And I was able to reach out to some of our students in this program to get them to assist with that. And they learned so many wonderful things. You know, so I'm not as nervous about that now, actually seeing it working as I was originally. So I think that kind of covers my requirements. How about you?
Karl?
Sure. I was trying to be responsive to the person who wants displays.
If it's too hard,
It's not hard. It's not hard. But it'll come up in a second, I guess. There it is. So this is our website.
See, it wasn't hard at all.
excellent.
And we have a certificate program. Now, I think this reveals something, because this is what it was up to this year. Looks very much like a few of the slides you saw this morning, and it sounds very much like Sherry's program. We have these basic required courses. What we did was, to a large extent, like lots of programs, is we went to our standard course list and said, okay, which of these course list items are we going to shuffle over here and count as getting you to this certificate, right? And I think if that's all you're doing, while that's not a disservice, I think it is a service. Again, it's like the guidebook to France. That's a good thing. But I think if the dream is that you're actually offering people a real substantive signal of some kind of competence, right, which actually is the dream, right? I would love it if someday someone said, oh, that Drexel certificate means like an LLM from NYU, that person's pretty good at this, right? There's some real differentiation, and that's the hope. Is that somewhere in this program there has to be that point of differentiation, and we lay our bet on two things. Something we call a Keystone Course, and then something we call a capstone experience, right? And we use Keystone because we're from Pennsylvania. The capstone experience relies on the fact that one thing that Drexel is famous for is co-op, right? All of our students are allowed to go work for a semester as part of their law school experience. The ABA doesn't let them make any money, but it allows them to get out there for course credit. And so it's like an externship, it's like a field clinic or what have you, but they basically go to work for half a year. And we have specific co-op placements for people who are in our concentration. So the General Counsel of GameStop, a very popular co-op, because you get free stuff, happens to be based near us. You know, we're in the city of Philadelphia. There's a lot of banks and an SEC regional office and so on. They take students and let them come to work for free. They are very happy about that these days. Okay. That comes with some academic support provided by the university. We have people who are so-called co-op professors, and they provide practical support and how to survive in a law firm office kind of discussion and so on. The other part, which I'm particularly interested in, is the so-called Keystone Course. And it's very much like a deals course that is out there, except the one difference is that it's 100% simulation-based as opposed. So unlike a deals course where you give people a stack of documents and say, hey, go figure out how this deal got done based on what happened, our course is one where here you're given a description of a situation. Last year it was a family business that was half in the hotel development space, as a franchisee for Holiday Inn, and half in the construction business. And the way they got into the business was one of their construction clients failed on them and they ended up owning the hotel. Right? And one of the sons said, oh, I could do this. And now they have 4. It's over-levered. The bank is knocking on the door. They're cross-collateralized. How do you solve that problem? It's a very rich vignette that they're given, and they spend the semester solving the problem. From hiring the investment advisor to fighting with the vulture fund that's providing them bailout financing, to ultimately the way the transaction ends up is they sell the hotel business to somebody else. Actually, they sell it to the one son who wants it, who has a partner from law school who's going to help them finance it. Right? And that's a simulation class that you take in your second semester, second year, as a way of getting exposed to deal skills, the difference between transactional lawyering and litigation, and hopefully gives you a little bit of a jump in how, what the things you need to know in order to do a decent job at your co-op. It also whets your appetite for the advanced curriculum. Having had that exposure now, yes, I would like to take private equity. Yes, I would like to take M&A, and it's something more meaningful to me than it might be if it was just taking it after taking BizWorks. It's not just another upper level class. And so that's our.
Can I ask a question? I don't want to interrupt you.
Please.
2 years ago, I heard you talk about a class, if I'm remembering correctly, where you took the students into various practitioners' offices.
That's this class.
That is this class. So it's you supervise and then they.
Yeah. The way the class gets run is it's in 4 units at the moment, since it's a long story. We're in 4 units. Half the unit gets conducted at a law firm or business. So let's take the vulture fund situation. The students role play, right? And they have a job. They're given, in this case, they were representing the company that was raising the financing. Their job is to review a term sheet. It's a financing proposal term sheet. They role play with each other, and then maybe with me, depending on the situation. They attempt to draft the comment letter and so on. And then the end of each unit is we go to some place. In this case, we went to a vulture fund. And the exact same exercise the students have been doing for a couple of iterations now get done in front of them by a set of real lawyers / vulture fund investors. And the students don't get judged by them. What the students get to do is compare what they have done to what an expert does. So they get to juxtapose their own efforts with the efforts of people who really know how to do it. And it's the theory is, and it works, is it creates that aha moment. That's what I try to, that's my phrase for it. You go, wow, that's what it looks like when it gets done well. And I actually have developed a bit of a sense of what it is trying to be done, right? If I sit here and said to you, this is what a vulture fund term sheet, I wouldn't call it that, a subordinated debt lender's term sheet is supposed to look like, and I talked at you about that, your reception for that material will be one thing. If you've tried to do one yourself for 3 weeks and struggled with it, gotten close, and then watched someone have that conversation, the receptivity you have to that experience is very different, right? And then the engagement you have with the demonstrators after the fact is even more different. You now have a real peer-to-peer kind of conversation. That's that class. Yeah.
So are you connected to the web?
There it is. Would you like to? I'll find it for you.
It's SDCL.
ST. South Texas.
Yeah.
Picky.
Sorry. I couldn't see from here.
There we go.
Okay. Maybe I don't.
Yeah.
Sorry.
Didn't translate. Nice website.
Okay, so this is just the short form description for outsiders, rather than the more detailed description that students can see. The general framework of our program looks like most of them, right? So we have some required courses. We've decided that the things that all students ought to know if they're going to be doing transactional law, they should take corporations. Our course is called Agency and Partnership, but it's really unincorporated business laws, and secure transactions. We have then a requirement that they take 3 courses from a list of elective courses. The list is comparatively short right now, with the safety valve that I can approve a course that they request. There's a peculiarity that explains why we kept the list short that you don't want to care about. It just has to do with the GPA requirements. We were afraid that if we made the list too long, students might be discouraged from taking some courses that, because they would count for the GPA, that they might otherwise take. So we kept the list modest. And then the skills component, students must take, I guess, following the construction metaphor, we have foundational skills courses. Right now we offer 3. They're really just variations on the contract drafting course that many of you may already teach or have seen somewhere else. One we call contract negotiation and drafting. One is contract building blocks, and the third is, I think we are now calling it commercial real estate finance practice. But even though their emphases are slightly different, the focus is basically the same. It's taking the deal and translating it into words, and then careful attention to the draftsmanship. And we typically have students take that in their penultimate semester, although they are not obliged to. But we want them to take that before they take then our capstone course. And this is we presently have 3. A 4th one is will be offered in the spring, next spring. These are simulation courses. One is built on a corporate problem. One, an international business intellectual property problem. One is a real estate, sort of a middle-sized real estate development. And the new one in prospect is an energy problem that will involve the acquisition of an offshore oil rig. We're still assuming people will be drilling offshore, together with an operating agreement and so on. Those are really sort of the skills component. We expect students will take that in the last semester. It's an extraordinarily rigorous sort of course. The students will draft 4 or 5 complete documents. Not every document that you would draft in a deal of that kind. They do complete what's essentially a closing list for the end of the course, identifying who would have been responsible for drafting, typically who would have been responsible for drafting the various documents that didn't prepare. But to give you an example of the level of complexity, in the corporate course, the problem is basically a management leveraged buyout of a family-held business. It's we're trying to eliminate the securities issues, so the centerpiece. So it's a reverse triangular merger, and the core transactional document is the merger agreement, which may end up to be for your 50 pages that they're working on. It's done with other people's money, so they're doing a loan agreement, and they also do a security agreement. The problem is got a little twist in it, so there's a mezzanine financing aspect, and so they need to do a shareholders agreement. So there are really 4 pretty major documents, and then they do an attorney opinion letter This is supposed to be the opinion letter offered by counsel of essentially the resulting entity about the financing, not the mezzanine financing, but the loan agreement. So it's a very substantial amount of work for students. And one of the things that makes this productive, it's small, it's team taught, 16 students max. It's team taught by a full-time faculty member plus an experienced adjunct. And students work on the documents in small groups, but they spend hours in face-to-face review sessions with the two teachers, going through their documents essentially line by line. So it's I think a very rewarding experience. What we're trying to do is to have the two teachers do for the students what maybe a partner would have done for a new associate. We do have a writing requirement, but like all law schools, but we don't do anything here except to ask that students write on a topic that's relevant to transactional practice. And I'm the arbiter of that, and I've tried to be pretty liberal about my interpretation of topics. And then we have some GPA requirements about which I'm uncertain. Well, I wonder, are there things that you'd like to ask about or complain about right now? Yeah.
Have you had any organized input from prospective employer community, surveys, advisor committees? I mean, what are they? Do you know what they're looking for when someone gets that certificate?
Let me speak for myself first. Oh, I'm sorry. Yes, thank you very much. We were supposed to repeat questions. So the question is whether we've had any systematic feedback from the bar about the effectiveness of the program and whether the certificate has merit.
What they'd like to see in the courses as well.
Okay, and what lawyers would like to see in the
what skills they want them to come out with.
Yeah. Well, we start like Sherry. We started with a center that has an advisory board. The advisory board includes transactional lawyers practicing in a variety of settings. Some are in-house counsel, some are at big firms, some are in small firms. We have several solo practitioners who do transaction work. And so initially, we met with them and solicited their concerns about what they would be looking for. And in part, that went into the structuring of the simulation courses. In addition, each of the simulation courses is co-designed by our full-time faculty member and the adjunct who's teaching it. So in each case, we have folks who are very, very experienced. And so in the corporate course, we've had partners from big law firms who are doing M&A work, for example. In the international /IP course, the co-teacher is, well, she used to be intellectual property counsel at Hewlett Packard. She's now at BMC Software. And so we're trying to get people who are on the cutting edge of the practice issues that they're seeing, contribute to the construction of the problem, as well as the things that we do. But more recently, we brought our advisory board together, gave them the skills the Pratt report says that all lawyers are supposed to have, and engaged in about a 2-hour exercise with them in installments, asking whether these were really skills. I mean, McCrae is advocacy oriented, and so we asked them. I'm sorry.
So is the Carnegie report.
Yes, it is. So we asked them to say to what extent these were skills that they thought were important for transactional lawyers, to rank them, and to add suggestions of things they would want to supplement. We just did this in the spring. It was very interesting. It was also very, I think they learned some things too, and they began to realize when they wanted to discount certain skills, and realized, oh yes, as the 30-year lawyer, I'm not really doing that, but I've got somebody else who's doing it for me.
Or you don't know you know it.
Well, there's some of that too. There's some of that too, yeah. So we haven't really digested all of that information yet, but it was.
Will you publish it, or?
Well, we'll have to see. We'll have to see. Others about input?
I mentioned earlier that I did seek the input of local practitioners, our alums. Part of setting up the center, we wanted to re-engage our alums. Not that they weren't engaged, but there are some that maybe could have been more engaged. And also to get other alums that are just out there with so many valuable things to offer, to get them more engaged. So we have also established a board of advisors. This is our marketing materials, trying to get even more. We have founding partners who make a significant contribution to the center, and other board members who make a lesser contribution. Most of them are just a function of where they happen to be in their practice, and some that have been out less time don't really have $10,000, $15,000, $20,000 to do that. I'd be happy to let you take a look at this. We not only have, we tried to pick a good array as well, but we also have some of our alums that are no longer practicing. Some that are, presidents of companies or vice presidents in various positions. And we did something very similar actually this spring. I don't know if we're maybe on the same car right here, but we did have a big board meeting to discuss what skills do our students really need. And we had the most fun day. I was the facilitator, which is really not my job description, but I had so much fun. I'm talking with our alums about how many cool things we could do through the center. We had been thinking about setting up a small business clinic, and we have now gotten that approved by faculty. That's my summer job, to get that set up before the fall. No pressure there. But we did get a lot of input, and it was a lot of things that we knew, but a lot of things that maybe we had not completely put in writing. For example, project management skills. That came out so many different places. And so obviously we're going to take this information back and synthesize it and decide where we can fit that into our curriculum. The certificate program actually got out ahead of that, and I can see that perhaps some of the courses that I'm going to be designing going forward, we can incorporate a lot of those comments that our board of advisors have had. So I think that they are going to be very instrumental in not only what we've done, but in helping us grow and improve upon what we've done. Again, my program is only 2 years old, so we are way behind the wave on that. But in our area, we're the first one to do a transactional law center and to offer the certificate program. So I'm really very excited. And while I have the microphone, my admissions office and our director of development really thinks it's a great idea to create these really cool things. And they're on our website. I'm happy for you to take a look at that. You can see where I had a really bad hair day on the front page. But just to get out and market, to new students. Obviously, we're always looking for some new way to set ourselves aside from all the other law schools that are in the nation and in our region. So we're taking, some of this and packaging that. So I'm happy to have you take a look at some of these materials, because it does talk about some other innovative things that we're doing, but I'm getting beyond my area of expertise there on this question. But I'll let Karl chime in.
Well, I think one of the great opportunities that's unusual, unexploited, is using practitioners in this project. Because I think someone mentioned they don't even know what it is they want, right? Practitioners are just terribly not particularly articulate about what expertise consists of, and most of them. And I think even the ones who are spectacular at it, if you ask them, well, what separates, this is my favorite question, what separates the people who you put on the list as the 10 best deal lawyers you've ever dealt with and everybody else, discounting for experience? Because you clearly have in your mind a difference, right? There are these 10 experts, and then there's the mediocre middle, right? And there's something that separates the two. What is it? If you could distill that for me, then I could figure out how to teach it, and boom, you'd be paying me a lot for that offer, right? And they try, because that's an inquiry we try to have with them all the time. And in this class I do, where I go to these, firms every 2 weeks for this exercise, that's the last question of the day for the discussion. And I tell them, because of course students are very hungry for the answer to this too, right? If you could tell me what it is I need to know, especially what I need to say I know at the interview, that would be a very useful thing. And invariably I get the same platitudes: attention to detail, good writing, what the heck does that mean, and so on. Not a lot of very great thought, but everyone knows it when they see it, right? They do, and I think we all do, right? And so how to distill that down to something. And I think actually I've come to the point where I don't think you can. Right? I think the discussion this morning between Dent and Gilson was sort of about that. Gilson still thinks you can. If you find the law and finance theory that explains everything that happens in a deal, and you teach the theory, people will instantly be able to be really good. They'll all be like Joe Flom. Well, the fact is, like he said, there were a bunch of 12-year-olds who were Joe Floms, and it was going to happen, and they end up being Joe Flom, and the rest of us have to teach for a living. So, but that's a long-winded way of saying I think the answer often lies in watching. Right? It's not in distilling and explaining; it's in watching, and that's what apprenticeship is about. You follow someone along, and you watch them do it, and you assimilate through that process this inarticulable thing called expertise. Right? And so, to the extent we can create opportunities for students to watch, is I think a very valuable thing. And alums and practitioners are the things they should watch. They should watch people who are good at it. And creating a way to do that efficiently might be a lot of the answer to doing a better job, in my view. And it also happens to deal with one of the other problems, which is lots of practitioners who are really worth watching are really bad at teaching. And so it's not the answer to say, oh, Joe Flom, come teach my M&A class, because he probably will do he may not, but some of them will do a really lousy job in this setting. Whereas if you could bring people somehow to tag along with him, it would be very powerful, except you have to bring people who can tag along who know enough to get something out of watching. Right? And so this course I described, that's the theory of that class. I am trying to give students enough of an exposure to what it is they're going to see so that they're intelligent watchers. But then I give them the chance to watch, right? And I bring practitioners in who are probably not very good teachers, or some of them are, but if I ask them to do what they do really, really well every day, it's like water off a duck, right? They walk in 2 hours of demonstrating how to negotiate a term sheet. If they're not thinking about how to teach it, they're just doing it, it's a phenomenal thing to watch. And you just have to bring the students to the point where watching is actually a meaningful thing for them. I think that dynamic in a curriculum ought to be replicated every possible place we can. Right? And so guest speakers become different. It's not really guest speakers, it's guest demonstrators, these simulation classes and using demonstration. And then I think you get a lot of feedback from people out in the world about how you're doing, because now they're very much invested in the program in a way that's actually powerful and not too hard for them to do. Right? They're not frustrated by the fact that they're not particularly good PowerPoint lecturers and so on. And that's worked very well.
Yes, ma'am.
I teach at a school that doesn't have a program like this. It doesn't have a course like yours. And 2 years ago, I sat and was very inspired and was going to go do it. And 2 years later, I've done nothing. I'd like to come back in 2 years and tell you how it's going. So what I need this time is a little bit of guidance. You can go back in time, and you guys too, before you started. How much administrative time did it take, taking away from your teaching and your writing? How did you figure out who the adjuncts were? How much time does it take? And do you guys give course relief, or if you're doing this in another course? So what kinds of steps can I start to take at a school that doesn't have a program, that has a faculty that's going to be a little bit resistant to it, but if I can show them some of these benefits, will come along?
So where are you physically living?
At Hofstra in Long Island.
Oh,
so we have New York City.
Yeah, it's a huge.
It is available to us.
Right.
Okay, so if we're supposed to repeat the question.
The question is, how do you set up one of these courses? How do you set up one of these programs? What are the first steps?
The question has to do with really the initial spade work in creating a course that has this sort of, I think you have in mind the simulation.
Yep, and then the
transactional
part
simulation.
2 is how much administrative time does it take from the faculty to find the adjuncts, mentor the adjuncts, supervise the adjuncts, etc.
So, and also then not only construct, but also the monitoring
and execution.
especially with adjuncts and so on. Well, I don't teach one of the courses and haven't created one personally, so this would probably be better for somebody else.
If I may just quickly.
Yes.
I think this is the primary value of a transactional center. Because besides the certificate program and all that, what it allows you to do as a political device, if you will, or an organizing tool, is it's a way of getting resources attracted to this project and projects like it, right? Because if you can't have a center or something like it, that means it's going to be on you.
Right.
And having a transactional center then creates this body that's not faculty person, it's a body that has some institutional spillover benefit, right? That you can advocate for. Right? So you go to the dean and your fellow faculty members and say, we're building the center, therefore I need this time to do this, right? As opposed to, I need release time in order to build this class, because that's about you, right? Not about this institutional project, right? And if the institution doesn't want you to have an institutional project, well then it's on you. And you have to decide whether it's worth it or not from a joy of life point of view, right? And it's not. It might be. But it'll be all off of your good wishes or good intentions, right? And that's why, I mean, I think I hide behind my quote center a lot, right? I get a budget from that. I get administrative pay from that. I get rewards for having built this thing that looks better and better on a website and seems to have more substance to it every day and whatever. The fact that I bring 20 high-powered lawyers in for an advisory meeting, the dean realizes that. I get credit for that. And all those things give me institutional freedom that I wouldn't have if I were this crazy faculty member who's trying to do a new course. And so that, frankly, I think is the greatest benefit. It's an organizing tool. It's an umbrella. It's a way of sucking resources out of the organization in a way that is just a faculty member can't usually do.
Well, I don't have personal experience creating a course, but I entirely agree with Karl about the relationship between having a center and then sort of the curricular innovations that you might be interested in. We were lucky because my colleague David East and I went to the then dean and told him what we were interested in doing, and the dean immediately bought into it. And part of the reason he did is that we had already been talking to alums, and we had them involved as well, and they wanted to say that this is something you need to be doing. Right? So the message was easier to sell at that point. But then starting with the center, having the board of advisors, having that, I guess, leverage, did facilitate moving things along. And I know that David East has been the co-creator of 2 of our big capstone courses, and he will be working on the 4th one as well. He has gotten accommodations, release time from teaching or reduced teaching or something in order to do that.
And since I'm a newbie, I don't have a lot to add, aside from the fact that our dean actually had this idea about the centers because he had come from a prior law school where he'd done this. So I was really very lucky because it was pretty much just us getting on board with the ideas. But it has been, the center has been a tool to get other faculty members who are otherwise way overworked, overtaxed, over everything, involved in some of these other bits and pieces that are not all litigation oriented. So it's been a slow process. I wish it were actually moving more quickly because I still feel like I'm a very small island in the transactional world amongst this huge, large advocacy world. But I'm definitely making headway, getting more buy-in from the faculty and alums and the university at large, et cetera. But that has been very helpful because now I'm starting to see things taking a turn. Getting this clinic is a huge deal. So it had been proposed apparently years ago, and it was never passed, but this has been an impetus. Look, the center's bringing in lots of very high-powered attorneys. We're doing a lot of skills instruction. Our alums are excited about it. The practicing bar is excited about it. The faculty's getting excited about it. So it has been a great tool to really start to bring more people in, get them involved, and to create some excitement, create some new programs where maybe if it were just Sherry doing it, perhaps I would not have the ability to do that. And I do have some relief when I'm setting up these new programs with some of them. Supposedly I have a half teaching load. I've never actually seen that half teaching load, but I have been relief to set up this new clinic. That will be all that I'll be focusing on this next year. So hopefully Build It and They Will Come would be my story.
Okay.
I think Hofstra would be a perfect place.
It would be.
I'm
And we
shocked I
have-
don't have a set.
We have a small business clinic, and we have a bunch of us that teach skills. This afternoon, my exercise demonstration that I'm going to do is about skills and doctrine. And the theory is, remember that commercial from the 70s, you got chocolate on my peanut butter, you got peanut butter on my chocolate? Our faculty thinks that we are divided into doctrinal and skills, and I don't think that's actually possible. So there's pieces of it everywhere, and we are so ripe for this, and we're so there. When I think, and 2 years ago, I swear I left, I was like, I'm going to do this is going to be great. And then 2 years went by in a second, and here I am sitting here thinking, I really should have done something. And I want, it's so ripe for it. I have to figure out the right way. But what I need, all of what you guys are all saying, which is true, is we need buy-in. I need everybody to see how it's going to help them and not take away from their writing and teaching time. You know, and that's the trick.
And that's really hard.
Yeah.
I'll tell you that. That is very hard because I'm one of them. I practiced for 15 years before I came to the law school. But I will tell you, I went to individual faculty members and said, hey, what do you think about my crazy idea? And they're like, initially a lot of the reception was like, why are you bothering me? I need to write.
Right.
However, once I had these kept having these discussions, got a few people to buy in, it's growing. It's not universal. There's a few that are maybe not, yay, Sherry's doing this great thing. But it's definitely grown in the past 2 years, and I think we're going great places. So I found that personal interaction really helped. I don't know if that's how your atmosphere is, but that really helped me.
If I have a structure and I can show my IP person how they would fit in, and it's all done for them. I'm not asking them to make a simulation. I'm not asking them to grade anything. I'm asking them to do what you said. You're asking, come in and do your thing. And law professors love to talk, so it should, but I have to figure out how to build that structure, and that's the tricky part.
I actually have one comment and one question. The comment is about, first of all, my name is Danny Bogert. I'm from Chapman Law School. The comment has to do with how do you get people to buy in. I wonder whether the change in the marketplace, the legal marketplace, is going to make things, is going to markedly improve our ability to persuade faculties and especially deans that resources should be allocated. Not necessarily because it will allow students to get jobs immediately out of law school, but because the employers, how students are being employed, when they can expect to find that employment. In California, firms don't even look at students until after they pass the bar. So we're talking about major law firms. The pattern of hiring has changed dramatically. And the idea that students are readily capable of practicing has become a very different thing when you have so many unemployed lawyers in the marketplace. So I wonder whether that isn't a change from 2 years ago. I was looking at some of the material that had exploded by, and it's an argument I've had with faculty at different schools and in schools I've taught at about the substantial writing requirement. And I'm going to ask a question. And it'll begin with my own bias, which I think is almost worthless from the perspective of teaching transactional practice. What is the point of a substantial writing requirement when it is usually implemented as follows? It is a research memorandum that looks like a law professor's attempt to teach how to write a law review article. The substantial writing requirement for transactional practice should be very different. And it may be satisfied from within the courses that you're already teaching. It should be the ability to produce, on more than one occasion, the type of work, what I call student work product, lawyer work product, that a lawyer would expect to see in practice. And they are not going to see a 20-page memo in most transactional practices. So I saw it in yours, and my guess is if I went through some of the others, maybe not all of the transactional centers, but my guess is I would find it in at least half. the substantial writing requirement continues to be part of the curricular necessity that a student must fulfill.
Danny Bogart's question goes to the substantial writing requirement, and you point out the disconnect between what substantial writing requirements are typically like, the sort of student scholarly exercise, and what would be appropriate for a transactional program.
Right.
I entirely agree with what you're saying. All we have done is simply to try to accommodate the fact that we already have an existing writing requirement, and just to tweak that a little bit for purposes of the certificate program. But what you're suggesting would require essentially saying, for purposes of the certificate program, the substantial writing requirement should be satisfied in a different way.
Correct.
And that's simply a battle that I haven't tried to.
Or an
fight
additional
with my
writing
team.
requirement,
Yeah.
but it doesn't make sense to me to put it in the transactional program, something which is, again, litigation, adversarial, memorandum oriented, which is what I've already been trained to do.
And so backward.
Yeah.
And I had been wondering about the same thing. Barbara Lenz from Wake Forest, because this writing requirement, because the ABA says you need an upper level writing requirement.
Yes.
And so you need the nature and everything, blah, blah, blah. Why can't that be a portfolio of deals? You do a lot of writing to put that together. And if we could find a way to say that you satisfy the writing requirement with one of these deal courses for a simulation, we get institutional support because everyone has to have that. And that's where you get your small class at law school. How do you marshal that energy to do it?
Well, at our school, we bifurcated that, so there's a drafting side and a research side. I felt strongly that I thought the drafting would actually fall nicely within the certificate requirement. And most of my students fulfill that in contract drafting. They draft, ultimately it's a final large asset purchase agreement, including schedules and exhibits, which I think is more appropriate for that. But there's also the second part, which is the research part. And I didn't actually think about really fighting that battle as to whether I should
Well,
discuss
blame you.
that. Yeah, because it's a much larger discussion than we could probably have in the next few minutes. But it's certainly something to think about, because I'm okay with that drafting part. The research part, I'm like, I don't know. At least I can have them focus on what we can call transactional topics. You know, something maybe an area of interest. Perhaps we're working in the clinic and we have an issue where, actually I have a potential client right now that two nonprofits want to merge. You know, maybe that's an area that's ripe for some research and some discussion. I haven't gotten that far yet. You know, so that's kind of where I'm looking at with that. But interesting point that you raised.
Yeah, just quickly, we had a classic, you know, here are the list of requirements for graduation. Let's slide them under our certificate, and that's the way we did it. But we just abandoned that. So we have no separate writing requirement for the certificate at all. And my law and finance class counts towards your upper class writing requirement. So if that's how you choose to do it, you can do it that way. You don't have to. Well, you do in the sense that it's a required class for the certificate, but not because of its writing component.
Just one more thing. Barbara, you were talking about the upper division writing requirement, and the draft ABA standards that we were talking about earlier today. As I read this, it still leaves open the possibility that
Which is what we do.
rigorous
Right.
upper division writing requirement be satisfied by something other than standard research.
Perhaps we could get that into an interpretation or something, so that it makes the battle easier, or there's no battle.
Or we can just collect how many schools already do it,
Exactly.
and it's
Exactly.
fait accompli, right?
A lot, we did it, a lot of them really do now. They'll have briefs and transactional documents, as long as it's enough in paper and as long as there is some research that's underlined, because you can't draft it back here.
So we allow email. No, we don't.
Twitter.
I think we had a question here.
I do, and it sort of ties in because when I saw that you break this up into a drafting and a research, so I will reveal my bias. I am director of the law library. I teach advanced legal research, and part of what I had noticed was when we teach them to research in context, it's almost always advocacy, right? Or it's this law review research style. And what I'm trying to figure out how to do is change that. And so I was curious, when you break it into this drafting and research, it almost sounds like from what you said that that research part is still sort of the law review research paper, which I personally think is missing a lot of research teaching. But so is that what's really happening? Or?
Well, you know, this is our first year with the certificate program, and I've had no students come to me with that. Now they've all fulfilled their drafting requirements, the research requirements not so much. So I would welcome any comments that you might have, because honestly, I've not really sat down and given it an incredible thought, because that's a law school requirement that really got pushed in with this. And again, I'm fine with that, but you know, what other areas could we, you know, have them do research? And I honestly have not really sat down and analyzed that whole
Edgar business
absolutely.
information. I mean,
Well, so in the Law and Finance class again, so I love this class. We don't have any background material. I mean, they get the case, the fact pattern. There's no form, there's no book, there's no treatise. There's a bibliography, and it's actually someone in the library a couple years created this, and it's, you know, all linked. You click on it, it takes you to the form book, it takes you to the treatise, it takes you wherever, it takes you to the ABA guide or whatever, and it's enormous. It's actually much too much information. Every student gets an account at the Practical Law Company. They owe me another bag, which is of middling quality, but still it's a good starting point. We think of it as, you know, it's just like an associate, right? Now, sometimes I'll throw a form out there if it's a little bit too difficult to start, but the idea is go figure it out yourself, and that is research in the transactional sense.
but did they get any on how to go figure it out by themselves other than the bibliography?
No.
Okay.
And well, actually, I take that back. The librarian who did this comes and gives well, it was Rob Richards.
Okay.
And now I can find another one.
Can I add? There is, for many years, I added a research project into my commercial leasing class. I just found it overwhelming, the number of assignments I had. Because it occurred to me that the type of research projects, if you really wanted a research project that a transactional attorney did, look very different, but it's not that they aren't assigned. So, for example, an associate in his first 3 or 4 years will be asked to do research projects by partners in the law firm. But typically they ask the following question. They say, we are using the following document. And a transaction we just engaged in has highlighted the importance of revisiting the document and a provision in it to see whether or not it is appropriate. Please go take a look at the exculpation provision, you know, the exculpatory provision in this commercial lease agreement where the landlord says he's exculpated from acts of his own negligence, and tell us whether we think it's going to be enforceable in the next couple of years. Now, the lawyer wants no more than 2 or 3 pages, and at the end he wants a marked up provision. Now, that's a very specific kind of transactional research project, and it's doable. And it seems to me that that's something, several of which combined ought to meet a requirement for writing and really would fit and allow a lawyer to work in transactional.
Well, your point echoes something that we heard from our advisors. I mean, we had many of the more experienced transactional lawyers saying, legal research, man, that's so important. Because they're not really doing they're not doing legal research the way the brief writer is doing legal research. It's much more targeted, very specific, narrow kinds of.
Well, I think the students want it, because when I teach advanced legal research, I put out part of the semester, and then they get to vote on what the other topics are. And every single year they've chosen business research. They usually choose securities, you know, the tax. So it's something that I think they want, and they're not really getting elsewhere. So.
I think we overlooked your question. Yeah, yes, ma'am. I'm sorry. Yeah.
This is back to the spade work issue. Do you each have a physical place that is the center?
It's a great question.
Because I am thinking, money, where does the money come from for that?
No,
Okay, so you're just like in your office and you have students who,
I'm a virtual center.
you're virtual, that's a good way to put it.
The theory was we would have one, but it didn't work out.
I mean, I'm not even, I don't even know if Tina Stark does. Here we're sitting in this lovely law school, but is there a physical place that is her center?
We do at South Texas. I mean, David is, we've sort of divided responsibilities. David East is the director of the center. I'm the director of the certificate program. We each have our own offices, but we have center space, which has a conference room where students can meet with their teachers in a small group. And we're putting together a library to go in the conference room, so that students have access to resources that they would regularly use. And I think right now we actually do have a part-time secretary. I think that's mostly an accident. I think that's mostly because she.
Well, you're hosed now. You just told the world.
I'll talk to Tina. I think what happened was she was assigned to two places, and then she lost half her job, and so it was, we'll just make her the secretary for the Senate. Well, we're running toward the end of time. I guess one of the things that we had in mind talking about is perhaps things we'd like to change about what we have done, or perhaps problems we found either in creating or implementing the program. Karl, would you like to start off with?
Well, I would. This question about the space led me to my wish list.
Oh, okay.
Because more than space, although I think space is a very, very important factor for a lot of reasons. I would love to have classrooms that actually were suited to transactional role playing and work. And this is a courtroom, right?
Yeah.
Pseudo courtroom. There's no conference table. There's no round around the conference table around which you can observe. I would love to have the technology that allowed me to record very easily what happens, those kinds of things. Now, going to law firms is a great thing. They have that, right? They have conference rooms that are set up for exactly this purpose, and they're free. So they even buy you lunch if you're nice to them. So, and I think it's very valuable, by the way, is taking students out there and making them put a tie on is a powerful thing. And seeing these places, right? Most of my students, when they walk into a law firm's conference room, they're pretty blown away the first time, right? The view is different than they're accustomed to. But the biggest one, the biggest thing on my wish list, I'd like to have colleagues. My thought of a center is it's like a department in a university setting, right? Where's my colleagues, right? And yes, there's someone in my school that teaches tax. He doesn't think of himself as part of my center. He will teach the tax class, but he's not committed to the center. Yes, I have people who teach commercial law, and yes, they're counted as, you go to my website, they're all listed, right? Yeah. But what I think is odd about centers, and this is not just transactional law centers, but in particular transactional law centers, because most faculties are probably saying, we got one, that's all we need. Right? Check the box, right? And you have to live by yourself. What I think is absurd about that is a center ought to have a critical mass of people who are focused on this enterprise. I think there's actually a 1 + 1 = 3 phenomena that could happen if that were the case. So I envy you, your colleague. If I were to, wish for things, I'd wish for 2, 3 people to spend time with on this project under the rubric of a center. And of course, I'd like to have a nice space that we can all do it in, and all those other things.
So one way you could get the space is to have a small business opportunity clinic, kind of at.
Well, then let me throw one other thing on top of the list. What I don't wish for is a clinic.
Okay.
Let me explain. Well, I think it would be great right? If that were, if Bill Gates' father wanted to give my law school, $500 million, sure, I'd build a clinic. Of course, why not? Right? I think they're great in and of themselves, but it's way down my list in terms of resources. I think it's very, very hard to deliver in a clinical setting what I would like to deliver in a transactional practice program. You, of course, will disagree.
I'll get back with you on that.
But I'd much rather invest my money in colleagues and more simulation, and more simulation using effectively and leveraging relationships with practitioners. I think that's a much more powerful tool than providing services to not-for-profits and small businesses. That's my view.
Well, if I might comment on something, I agree with everything you said. One of the things I think is useful about having a certificate program or a center or some blend of those things, it is to try to recruit colleagues.
But you have to get them hired by your faculty.
Well, I don't mean recruit new people. I mean recruit existing faculty. Right? I mean, part of the idea is to try to preach the gospel to them. Right? And the fact that you've got something in place and maybe they're only nominally a part of it at first, it gives you a little opportunity at least to start having conversations. And so even if all that means at the beginning is to convince them to integrate some transactional exercise or two in their business works course, even if that's all you do to start with, I think you made a step. And Tina said the first day yesterday that the folks that we're most dependent on are adjuncts and liberal writing teachers. But my colleagues who have been teaching doctrinal courses for years, who develop one of these skills-oriented courses, will testify that they feel like their teaching vocation has been reinvigorated. And I think trying to sell that message to folks. So you've been teaching business orders 25 years. Why don't we try to do something a little new? I think helps recruit somebody to the cause, but also maybe prolongs their teaching efficacy as well.
My program is so new, I don't know if there's anything I would change, although everybody has raised such interesting questions today. I'm sitting here rethinking how it is that we do things. So I think it'll be interesting to come back 2 years from now and see where all of us are. Hopefully you will be
ask the same question.
on this panel. No, you're going to be on this panel. You're going to be talking about your wonderfully successful center.
For sure.
But it is hard to get that buy-in. I can tell you, I still don't have it completely. It's happening one at a time, and when you get that person excited, I've had some doctrinal faculty take on something a little different, add some skills to their classes, and they're coming back to me like, really, that was pretty cool. I had another doctrinal faculty member come to me and say, I really like what you're doing with this board of advisors, seeking advice from them, and he attended our brainstorming session, and he said, what I'd like to do is I'd like to do that with some of our more recent grads. Why don't we get, and he calls it the Junior Attorney Roundtable, the JAR program. He said, why don't we get these junior attorneys, maybe who've been out 2 to 5 years, and ask them, gosh, what do you wish you had learned while you were here at Chase that you really could be using, when you got out to practice? So he took that all by himself and came up with a program and hosted, I don't remember how many attended, I think a dozen, relatively fresh graduates, and got, while they were very similar feedback from what we got from the practitioners who've been out practicing for a long time, there were some other little nuggets that were like, really we hadn't really thought about that. And we'll be incorporating some of that into our discussion as we decide, where to take the next program and developing some more wonderful courses, because I now want to come and take Karl's course. I'd love to develop some of those as well. So, but it just happens one at a time.
And your JARs are your adjuncts of the future, your board of advisors of the future.
Precisely.
That's the beginning of buy-in. It's like when you show someone an article and you say, do you have thoughts on this? And their thoughts are maybe helpful and maybe they're not. They're now invested. They're a part of that. So when someone says, what did you think of her article? It's a little bit theirs. And in the same way you ask these JARs what their opinion is, and they say, we need more X. And then 2 years from now you say to them, can you come and teach X? how great is that going to feel for them?
Absolutely. And I did not even, it was not even my idea to do this. It was the other faculty member. So slowly but surely we're getting buy-in. But that is, it's a challenge. It really is a challenge because it's still kind of us versus them. Because I'm the skills lady on the wrong floor. Most of our faculty are on the 5th floor. I'm on the 3rd floor. I do have space. I do have a place.
Does it have a sign?
It does have a sign. It has the name of my center wrong. Probably shouldn't have said that. We call them centers of excellence, and it has them in the wrong order, but that's okay. But that is kind of nice because we have 3 centers. Another is a local government law center that doesn't do exactly the same thing but has a different mission. And we're all actually in the same space with a receptionist/secretary, some additional conference meeting room. Although we're shaking all that up with this new clinic, since I'm going to be driving that bus as well, we're moving some people around. So I don't know if that's going to be good or bad because the center, the different centers actually end up having to be split because we'll have to have locations. So I'll have to report about that back in 2 years to see how that went. But I do actually have a space.
Well, we're about out of time. I regret that we ended up having a few people here, but the upside of it was this was a wonderful conversation, and I appreciate your questions and comments. It was very helpful for me personally.
Same here. Quality over quantity. Thank you all.
Thank you.